To understand it better, first we must know the difference between the constituent power and the lawmaking power. The constituent power is related to the constitution, whereas the lawmaking power is generally given to a body to run the general affairs of the country. As we can see, the constituent power are of two types. First is to create a new constitution, and the second is to amend the already created constitution. The people of India gave the Constituent Assembly the power to create a new constitution for India. Using those powers, the Constituent Assembly created the Constitution of India. The Constitution of India created many bodies, and one of them was the Parliament of India. The Parliament of India was given many powers, and one of them was to amend this already created constitution under Article 368. Other than this, the Parliament was also given the lawmaking power to make rules to run the day-to-day affairs of the country under Article 13. Article 13 defines laws as ordinance, rules, regulations, orders, bylaws, custom, and usage. As you can see, ordinance comes under Article 13 of the Constitution, which comes under the lawmaking power of the Parliament, which is different from the constituent power of the Parliament to amend the Constitution. Therefore, the answer to the question, can the Parliament amend the Constitution by way of an ordinance, is no. As we have seen in the previous video that the constituent power are of two types. First is to create a new constitution, and second is to amend an already created constitution. Now, the power to create a new constitution was given to the Constituent Assembly, and the power to amend this already created constitution was given to the Parliament under Article 368. Now, the power to create a new constitution which was given to the Constituent Assembly is absolute, and it has no limitation on its power. It can create any type of constitution it pleases. On the other hand, the power that the Parliament has under Article 368 to amend the constitution has inherent limitations because it can only modify the existing constitution. It cannot create a new constitution in itself. That means some of the features which gives an identity to this already created constitution must be maintained, and they shall not be touched upon. Over the period of time, the Supreme Court has pointed out various features which gives an identity to the Constitution of India, such as the supremacy of the Constitution, federalism, secularism, rule of law, judicial review, etc. Now, these features forms the basic structure of the Indian Constitution. This limitation on the constituent power of the Parliament to amend the Constitution has been expressively mentioned in some of the constitutions of the world, whereas in other cases it is implied by court's interpretation, for example in India, which arose as a result of a tussle between the fundamental right and DPSP, and also the interpretation of Article 13, which we'll see in the next video. Thank you.